Bangan Wominjikya Bangan Anajandak. I welcome you to our country, Larak Jajabarang Kundicha, home of the Jajabarang people. On behalf of the Jajabarang traditional owners and the Jajabarang Clans Aboriginal Corporation, I'm pleased to welcome guests and the public here this evening to La Trobe University's inaugural Talking Justice seminar. This evening's event is happening on the traditional land of the Jajabarang people. I would like to acknowledge the Honourable Lisa Chesters, Federal Member for Bendigo, ALP member, Mr John McPherson, Chair of the Advocacy and Rights Centre, and also other guests. I thank the organisers of the seminar for inviting me this evening to perform the welcome ceremony, share our cultural beliefs and the good news story on the settlement of our native title claim with the state government on the 28th of March last year. The second part of my talk this evening will focus on the Jajabarang traditional owner group's experience in electing to settle our claim for land justice under the Victorian Traditional Owner Settlement Act as an alternative to the Native Title Act, the Commonwealth Native Title Act. In this welcome, I will share with you some key Jajabarang beliefs of our culture and traditional practice to provide a suitable backdrop for why the recognition of the Jajabarang as traditional owners of this area is important, not just for the Jajabarang people, but also the wider community. For the Jajabarang, country is a living cultural landscape that is more than just physical objects and features. Imprinted in the landscape is our history, dreaming stories, lore, totemic relationships, songs, ceremonies and ancestral spirits, which give it life and hold significant value for the Jajabarang people. Our ancestral spirit is the eagle, and our traditional name for him is Bunjil, which represents wisdom, knowledge and power. Our ancestors believed Bunjil resided on the planet Jupiter. Just think about that. And the red glow, when you look at Jupiter for long enough, those that are stargazers out there, when you look at Jupiter for long enough, you'll notice that red glow. What did that red glow represent? To my ancestors, the red glow represented its campfire. The values that the Jajabarang people hold for their country are shaped by our beliefs that all things have a spirit. We call that spirit Murub. That is, it's found in the water, birds, plants, animals, rocks and mountains. Jajabarang people see all the land, the plants and its creatures in a holistic way that is interconnected with each other and with the people. The recognition and settlement agreement I will refer to later formally recognised the Jajabarang people as the traditional owners of this land we meet on today, which our ancestors cared for over many generations, countless generations. As the first people of this country, we can trace our ancestors back to prior European occupation, which is corroborated, of course, by accredited historical records and rigorous research. I did some of that research, and I'll come back to that in a moment. Today, descendants of the Jajabarang people proudly survive and continue their culture, customs, and abide by Bunjil's law, without, of course, conflicting with any Australian laws. The Jajabarang Clans Aboriginal Corporation is the legal entity for the Jajabarang traditional owners and it is based here in Bendigo. The corporation, with its small management and admin staff, is the vehicle for the implementation of the Recognition and Settlement Agreement that was registered with the National Native Title Tribunal as an Indigenous Land Use Agreement on the 24th of October last year, not very long ago. Contained within that agreement is provisions for caring for the environment, economic development, which are designed to restore the Dja Dja Wurrung community and strengthen partnerships with the wider community. Dja Dja Wurrung's traditional country traverses 12 local government areas. These are Baloke, Loddon, Northern Grampians, Pyrenees, Ballarat, Hepburn, Macedon Ranges, Mount Alexander, Greater Bendigo, Central Goldfields, Moorabool and Campaspe. You can find a map of our agreement area on our website. Just Google Dja Dja Wurrung. It'll come up straight away. I'm heartened to read on the seminar program that there will be a focus on a range of justice issues, including proposed changes to the Racial Discrimination Act, Section C, and constitutional recognition of Australia, of Aboriginal and Torres Strait Islanders. My presentation, however, will focus more on the Recognition and Settlement Agreement. I might add here, I was one of the plaintiffs in the Bolt case, but because of the time, limited time here, I could, I wouldn't do it justice in trying to fit it in here. But you can ask me questions about it if you like. I'm equally pleased with the good work that La Trobe University does in the student support space for Indigenous students locally and further afield. These activities provide a good foundation for developing enduring relationships between La Trobe University, the Dja Dja Wurrung traditional owners and the wider Aboriginal community. This evening's welcome to country highlights the goodwill and reconciliation between the Dja Dja Wurrung people and the wider community. The recognition of the Dja Dja Wurrung at these events helps to strengthen relationships throughout the region and promotes a positive awareness of the role of the Dja Dja Wurrung in local community activities. I would like to end once again by thanking the organisers for inviting the Dja Dja Wurrung to be part of this evening's event and the opportunity to share our Aboriginal culture and land justice story. I wish the Talking Justice seminar well over the weekend and also wish the guests and participants a safe journey across our country. That concludes my welcome to country, folks. Part 2 of my presentation is on the Dja Dja Wurrung people's decision to settle its claim under the Victorian Traditional Owners Settlement Act 2010 as an alternative to relying on the Native Title Act 1993 alone. In 2011, the Dja Dja Wurrung people decided to negotiate resolution of our native title applications with the State of Victoria under the new Traditional Owner Settlement Act. This is a story about that journey that will also touch on some of the factors that influenced that decision. Starting first then with past attempts to achieve land justice, let's look at the outcomes of land justice, land rights policy here in Victoria. The struggle for land justice in the form of land rights here in Victoria is documented in Wikipedia from the 1970s to the early 1980s. As a Dja Dja Wurrung traditional owner, I believe it has been an issue, as Martin referred to, of unfinished business since European settlement here in Victoria in the mid-1830s and has continued to present day. Nevertheless, the hopes of the Victorian Aboriginal community were lifted in the early 1980s when the New South Wales Aboriginal Land Rights Act was enacted in 1983. Regrettably, however, the Kane-Kerner Labor government's attempt to replicate the Act here in Victoria with the bill entitled the Victorian Land Claims Bill 1983 had a disappointing outcome, and I was part of that process before I got involved in the native title space. When the draft exposure of that bill went through the community consultation process with key interest groups such as, amongst others, the local councils and various other landed interests had their say, the fate of the bill was doomed. It was quietly shelved by the Kane-Kerner government. So land rights legislation as an option for the settlement of our land grievances did not gain much traction here in Victoria, unfortunately. It's different when you go up to Northern Territory. They have both land rights legislation, as in New South Wales, as well as they can access the Native Title Act. But down here in Victoria, we didn't have those. We didn't have that luxury. The journey that the Dja Dja Wurrung Native Title Group took to achieve land justice through the Victorian Traditional Owner Settlement Act was, for me, a unique experience. The journey began back in 1998, 5 years after the Native Title Act was enacted. As you may know, native title under the Native Title Act is the recognition in Australian law that Indigenous people have a system of law and ownership of their land that predates European settlement. It recognises that Aboriginal people have rights and interests in their land and waters through their traditional laws and customs, and it also includes the right to protect sites, hunt and camp and live on land, hold ceremonies, and have a say on the management of or development of land. Native title, as you know, only exists on Crown land and can't be granted on private land or freehold land. Nor can it take away anyone else's valid rights. So, you know, we need to put those myths to rest very quickly. The first applications lodged by the Dja Dja Wurrung Native Title Group in the late 1990s, that is 1998, were in response to the Future Act notices that we issued under the Native Title Act. And our first applications only covered 4 small parcels of Crown land. Unfortunately, 2 of these applications prepared by the then Native Title representative body at the time failed the registration test, due mainly to the lack of rigorous connection research. Also around about this time, the Dja Dja Wurrung were part of a wider community consultation which endeavoured to lodge a northwest regional claim comprising such groups as the Wadi Wadi, Wamba Wamba and Barappa Rappa and other Riverland Native Title claimant groups. The Native Title representative body at that time engaged myself as a Dja Dja Wurrung, and I have to say also here, I'm also a Yorta Yorta, member of the Yorta Yorta community. The rep body engaged both myself and Mr. Rod Hagan, who had previously done, an anthropologist, who had previously done genealogy research on the Yorta Yorta claim, to undertake connection to country research. We were both engaged to undertake connection to country research for the broader Northwest applications, which included ours as well. The research resulted in the registration of these claims. They did pass the registration test, folks. And an amalgamation of the Dja Dja Wurrung applications were included in a whole of country claim, which was lodged in 2000. Activity over the next 8 to 9 years on these claims occurred largely under the Native Title Act, but it was frustratingly technical, expensive and time consuming. Processing the Dja Dja Wurrung claim through the Native Title Act run into many hurdles. Not least here was the requirement that claimant groups had to prove a continuing connection to their lands and continued practice of traditional law and custom. Unfortunately, as the Yorta Yorta claim found, it is still difficult in settled areas like here in south eastern Australia to satisfy this requirement. One of the features of the new Act is that the threshold test is not as unrealistically strict as the native title test. You may all remember the Federal Court's Justice Only finding that the tide of history had washed away the Yorta Yorta's rights to land, which underpinned his negative determination of their claim. Now, you probably can cast your mind back to that period when the Yorta Yorta claim didn't get up, but it was largely around that problem of proving continuing connection. In the immediate period after the Yorta Yorta determination, there was much pessimism and cynicism in the native title space here in Victoria, where the successful native title claims were achievable under the Native Title Act. Exacerbating this mood at the time was the limited number of solutions or alternative measures for achieving successful outcomes. A consequence of this was that little progress had occurred with the other claims from 2000 to 2003 under the Native Title Act. However, things started to change when the then Native Title representative body was replaced with a new structure, a more professional and skills-based organisation, Native Title Services Victoria, which occurred in 2003. Some 2 years later, in 2005, with the support of NTSV, traditional owner spirits were lifted when the Federal Court issued the first consent determination for the Wimmera claim, also known as the Watchabollock claim. This outcome gave traditional owners a sense of hope that a shift was occurring in the native title space. Over the next 5 to 6 years, a further 3 consent determinations were achieved for the Gunditjmara in the southwest in 2007, the Gunai-Kurnai people down in the Gippsland in 2010, and also for the Eastern Maar Gunditjmara Part B claim in 2011. Of course, there were many naysayers soon after the result of the Yorta Yorta claim, many naysayers. But it was great to be able to turn that tide around and contribute to helping those traditional owner groups achieve their land justice. It needs to be noted, however, that on average, these and other claims were on foot for well over 10 years, and some up to 16 years. The key lesson here is that settlement under the Native Title Act alone is time-consuming and an expensive process, and one in which TOs, traditional owners, felt at the time that they had a limited engagement in. Against this backdrop, NTSV, Native Title Service Victoria, chose a more proactive engagement strategy with traditional owner groups across Victoria. A positive effect of this strategy, combined with the above successes I mentioned, in a way provided a basis for other traditional owner groups, not least the Dja Dja Wurrung, to leverage off that experience and knowledge gained from those successful determinations. Around about this time, the Dja Dja Wurrung were labouring over which was the best way to go. Persevere with the Native Title Act or find an alternative way to settle our claims. A watershed moment occurred in 2009 when the Brumby Labor government endorsed a new native title settlement framework policy to settle some of the 11 outstanding or remaining claims in Victoria. The difference between this framework and the Native Title Act process was that it focused on agreement making and direct negotiation with the state government as an alternative to the Native Title Act's court-directed approach, including the option of litigation. Well, the Yorta tried litigation, and that adversarial model, it didn't provide them with too many benefits. Before the November election in 2010, the Brumby Labor government enacted the new Victorian Traditional Owner Settlement Act 2010 as the enabling legislation for the new framework policy. The first native title claim to derive partial benefits under the new Act was the Gunai-Kurnai claim in Gippsland that was settled in September 2010, which accessed the transfer or provisions under that Act, which were the transfer of national parks to the Gunai-Kurnai. Ironically, the Dja Dja Wurrung claim was also meant to be settled in 2010, but due to limited funding from the Commonwealth, did not occur. The irony here, though, was that we had a federal Labor government and we had a state Labor government. We dealt with them, but the federal government was not prepared to give any ground to the demands of the state government at that time, which was led by one Rob Hulls. So you think you've got a sympathetic government in place, and you think that there's going to be a shift, but it doesn't always work out that way. A period of uncertainty occurred in the native title space during the transition between the Brumby Labor government to the new Liberal National Party government. The chief concern of the traditional owners and their support services was the likelihood that the incoming Liberal National Party government was planning to scrap the Traditional Owner Settlement Act. Those fears, though, were allayed when, after a period of some months of lobbying and negotiations with the new state government, it was retained, untouched. And I think that was a really incredible outcome. After the transition period settled in 2011 and the state government decided that the Traditional Owner Settlement Act had considerable merit and was a better way for resolving outstanding claims, the Dja Dja Wurrung at that time elected to negotiate resolution of their claim directly with the state under the new Act. In contrast to the native title Act's costly and time-consuming process, the Traditional Owner Settlement Act introduced a new alternative system for resolving native title here in Victoria. The Act also provided for out-of-court settlement of claims and the delivery of more rapid delivery of land justice for Victoria's traditional owners. The Act also allows the Victorian government to make agreements to recognise traditional owners and their right to Crown land, but in return for their agreement at the end to withdraw all current native title claims and not to lodge further claims in the future. This could have been a deal breaker at the time, but after the benefits and costs were weighed up, this condition was retained by the Dja Dja Wurrung people, particularly in our agreement. It did provide, though, keeping that clause of removing our future native title claims, it did provide an effective bargaining point for traditional owners to ensure that other benefits were satisfied before their agreement was signed off. In contrast to the Native Title Act, other key benefits of the Traditional Owner Settlement Act are as follows. It is a streamlined, expedited and cost-effective approach to settling claims through negotiation. It includes new outcomes to increase the proportion of Aboriginal people with access to their traditional lands and also to increase economic and social opportunities in Victoria. It also contributes to reconciliation here in Victoria through building stronger partnerships with Aboriginal Victorians, resolving long-standing land grievances and strengthening communities and cultural identity. Another contrasting feature of the Settlement Act is that the Dja Dja Wurrung people group was able to secure funding from the state to support the establishment of the corporation and to assist the traditional owner negotiating team to organise itself for negotiating directly with the state. This was a significant benefit during the pre-settlement phase. For groups settling only under the Native Title Act, usually funding is not available until after or well after the determination. The decision to settle under the new Act also had other important reasons. The decision was made not just on behalf of Dja Dja Wurrung ancestors and community members, but it was made with the interest of future generations in mind. In early 2013, the Dja Dja Wurrung negotiating team reached a point with the state government where they were confident to present the package to the Dja Dja Wurrung full native title group for authorisation. This occurred on the 16th of March and received state cabinet approval 2 days later on the 18th of March. The recognition and settlement agreement was signed later that month on the 28th of March in a formal signing ceremony here in Bendigo, and it was then officially registered with the National Native Title Tribunal in October last year. Over a period of just under two years, the Dja Dja Wurrung negotiating team participated in at least 50 meetings with the state's negotiating team, and these were often held at the weekend, usually over a 2-day period, and it was in that sort of in those meetings that we were able to nut out a suitable agreement. The key, if I could just summarise the key components of our agreement, it includes an Indigenous land use agreement, which is registered with the Native Title Tribunal, and that gives the Dja Dja Wurrung the consent gives the consent of the Dja Dja Wurrung people to all future acts in the agreement area. It also contained a recognition and settlement agreement package, which, as I said, formally recognises the Dja Dja Wurrung as the traditional owners of this area. The other key components of the agreement was a traditional owner land management agreement, and last but not least, a funding agreement, which provides the funds for the corporation. At the full native title group meeting in March last year, the group also authorised the Dja Dja Wurrung Clan's Aboriginal Corporation to manage the implementation of the settlement agreement package. The corporation, as I said before, receives funds to employ a small staffing structure whose responsibilities are to manage the operations of the corporation and the programs that relate to the settlement package. In summing up the journey towards land justice, I could say it has been a challenging one at times, but it has been a remarkable achievement for the Dja Dja Wurrung people. In the post-settlement phase, the corporation is guided by the Dja Dja Wurrung people, and the corporation is working hard towards the implementation of that settlement package. The key messages that I want to leave you with, and I got the nod before, of this presentation that I'd like you to take away with you this evening is as follows. The Native Title Act will continue to apply to Victoria, and native title applications can continue to pursue their native title claims through the Federal Court if they choose to. It is still their choice though in the end. However, the new system provides an attractive alternative to pursuing lengthy and costly court processes. The struggle for land justice has been a long journey for Victorian traditional owners, but through their persistence, resilience and creativity, they have been able to successfully lobby for key policy and legislative changes designed to achieve negotiated outcomes directly with the state government. The Dja Dja Wurrung Recognition and Settlement Agreement is the most comprehensive single settlement in Australia today. And last but not least, the Traditional Owner Settlement Act that I've just given you an overview on also offers a useful and practical non-litigated driven model for other states to emulate. That's where I want to leave it. Thank you.
Thank you very, very much, Graham. We have time for questions and I welcome them.
Thank you for that talk. Could you describe to us what activities actually the agreement now allows for Dja Dja Wurrung people locally in terms of access and use on land now?
Under the Natural Resources Management Agreement, the Act has provision for Dja Dja Wurrung members to hunt and gather in areas, but that would be managed and controlled jointly with the Dja Dja Wurrung and the relevant agencies like Parks Victoria and DEPI and so on. Some of the other areas that the package includes is that we have a economic development arm of the corporation which is a natural resource management team, and that team is negotiating contracts directly with the likes of Parks Victoria, DEPI and catchment management authorities as an income generating activity. That's a really important project because it provides employment and training for Dja Dja Wurrung members and also members of the wider Aboriginal community here. The other activities include the change of the Future Act system into an Indigenous land use activity agreement, which gives the Dja Dja Wurrung authority and involvement in works that are being carried out on public land and so on. And that is really aimed at protecting Aboriginal or Dja Dja Wurrung cultural heritage and so on. Yeah, so there's quite a bit happening at the moment. We're right in the middle stage of implementing the package that I've spoken about, and we have a very limited staff, but yeah, we're moving things along.
Yes.
Yeah, thanks, Graham. I'm just wondering, I'm trying to recollect, I know you're talking about 85 on the new state framework and the agreement between traditional owners and state crown land, but are there examples of private landowners and a facilitation process of an agreement between private landowners and traditional owners?
Not at this stage. There were a couple of historical sites that will be part of the transfer of land to the Dja Dja Wurrung, but these historical sites were already under the control of the state government. That is Franklin Ford near Dalesford, and also the Carisbrook stone arrangement near Ballarat. Yeah, so as I said before, a lot of our focus is largely on public or reserve or Crown land. Yep.
The 2010 Act was obviously a good thing, and was it Rob Hulls or someone else who gave it legs to give the state legislation off the ground and get the system running before 2010?
It was a combination of the tremendous support that Rob Hulls lent the process, but it was also a lot of work and that went into it from the Land Justice Group or the Traditional Owner Group that lobbied and campaigned for those changes, and also other. I shouldn't leave out other offices within the various agencies, Department of Justice and DEPI and Parks Victoria, that also got behind the changes that needed to be made. Yeah, but the irony was that the Brumby government were replaced. But as I said in my earlier comments, we were able to sort of get through that transition period and keep the Act still intact.
I've often heard Aboriginal people say that native title doesn't equate to land rights, and I wonder whether, I've also heard people talk about the merits of a treaty, for example, as opposed to native title or these other type of arrangements. I'm interested about what your view is on the merits of a treaty.
We went down that track when we actually negotiated the new policy framework with the state government. That's the Native Title Settlement Framework. The traditional owner negotiators that were part of that process debated and really just went through in every detail the possibility of a treaty as a measure for resolving this unfinished business. As we did we had also extensive discussion and debate over compensation package. But all that was weighed up, and we decided in the end that the framework was the way to go, and in turn the new Traditional Owner Settlement Act was the path that we chose to go down.
Can I ask a question? You mentioned that this was not only a success for your people, but something that might be followed, generalised. And it's a question from ignorance. To what extent, or two questions. One is, to what extent does it depend on the people you're negotiating with being well disposed? A court doesn't depend on that. The court presumably really doesn't depend on the other side being willing. So there's potentially some advantage in that if the other side, in different states, is less well disposed. And the other question is, I've learned a lot that I didn't know about why you think that it's very good for your people. What about the people who you're negotiating with? What was their calculus? Why were they thinking, well, we should do it this way? We're winning in courts because we're not losing, so why did they decide to move around?
You mentioned in your opening speech the moral compass and the issue of justice of an unfinished business. You mentioned the whispering in our heart. Those are very strong issues that impact on this process. But sort of going back to your first question, what benefit did the other side get out of this? I think negotiating these types of agreements with traditional owners saves the country, saves the government in the end. Quite a lot of money, because the longer that these other claims remain outstanding, they're costing money in that context. So I think the benefit for say the government side of the negotiating table was to the sooner that these claims are resolved, the less it's going to cost the taxpayer in the end.
This will have to be the last. Oh, actually, please, because you haven't asked before, this will have to be the last question. Otherwise, we won't get to drink.
Look, I'm interested in the whole notion of reconciliation, and whether you can actually fully reconcile what's actually happened. I'm not convinced by that, but I'm interested in whether what next needs to happen down that path of reconciliation, given that you have settlements and there's a whole process that's happening in the back around legal processes and management processes being set up. Well, what else are you aiming for in terms of sort of further down the path of reconciliation?
Oh, look, there's a couple of things I can say in response to that. For Dja Dja Wurrung people, it's important for us to be put back in the landscape. That's where we were in the beginning, and that's where we want to, play a really important role. And within that, we're no longer invisible. And the recognition of Dja Dja Wurrung as traditional owners, I think, goes a long way towards establishing a more visible role of the Dja Dja Wurrung in the broader community life of the local community. We're developing partnerships as we speak with a whole range of groups, community groups and key agencies, local government, schools, private industry, and a lot of that is what I call, practical reconciliation. It's putting the Dja Dja Wurrung not front and centre. We're not saying, we want to hog the show, but we want to have that, recognition of our role in society as equal members in this community that we, and on this land that we have to share. So I see the settlement package, in a practical way, providing many opportunities for that reconciliation. Those reconciliation activities to flourish, and grow.
It's a very nice way to bring this first session to a close, because in a lot of fraught situations you have empty moralisers on one side and deal makers without much moral compass on the other side, and each thinks very little of the other and they don't do things together. What we've heard is an extraordinary example, it seems to me, of morally driven, practical negotiation, hope, trying to get things into a form that people can benefit from them, rather than simply claim and stay on the moral high ground. So I'm grateful to have been here to hear it, and I imagine that you, who I don't know, but I decree that you, who I don't know, should agree with that. Thank you so much.